We had a closer look story this week, and boy, it's a doozy because in a landmark ruling, the U.S. Federal Trade Commission has ruled that non compete clauses in employment agreements are no longer valid, and all existing non compete agreements 120 days from today are null and void. The government argues that non compete agreements stifle wages and reduce the talent pool for all companies to draw from. Now, if you ask the businesses, they're going to tell you that they need to protect their intellectual property and development processes. The ruling came after 26,000 public comments were made on this case. After the ruling was issued, the U.S. Chamber of Commerce immediately filed suit and challenged the ruling as well as the FTC's ability to decide it. Now, there was similar action that was expected from the National Labor Relations Board around this same topic, and there were some that were saying that the FTC was kind of in a race with the NLRB to figure out who could get the news out the fastest. This is a big issue in enterprise technology because, according to the reports, 1 in 5 Americans are covered by a non compete agreement at any given time right now. Stephen, what should we make of the FTC's decision to invalidate all non competes?
Well, first off, I think that maybe we should talk a little bit about non-competes generally, because this is one of those things that you and I, Tom, when we go to Tech Field Day events or other events and we're talking to people from other countries and we mention non-competes, there's usually a lot of, wait, what? But this is not specific to the United States. There are non-competes in other countries as well. And I think that it's important also to point out that non-competes are somewhat controversial even here in the U.S. For example, in California, they've moved pretty aggressively to get rid of or to block any non-competes. And in fact, California won a major court case showing that they can invalidate the non-competes of other company or other states if somebody moves to a company in California. And that's a big, big deal. Similarly, we've seen a little bit of a back off from this. In fact, we talked about on the rundown years ago when Massachusetts decided to lighten up a little bit on non-competes. As I mentioned at that time, full disclosure, I've actually been the subject of non-compete action when I worked in Massachusetts in tech firms. And frankly, my opinion is concurs with the government's position on this, as well, I should point out, as basically every reputable academic study of the question. And in that non-competes do stifle worker wages, limit worker mobility, and limit overall innovation in technology. One of the things that I've long wondered is how come the high-tech industry in Massachusetts and the high-tech industry in Silicon Valley didn't sort of follow the same path. My position is that it comes down to non-competes. Effectively, you have situations in California, a lot of stories where people literally move to a company across the street or jump and start their own company and do amazing, innovative, and exciting things that would not have happened in Massachusetts because the employees would be worried about being sued or potentially even being blocked for years from working in the same industry. It's just not fair. Now, I'm not trying to say that non-competes are entirely illogical or make no sense anywhere. I could see for senior executives, maybe you might want to have a non-compete agreement, but I figure that it should be pretty rare. I felt like that's really what this whole concept was originally designed for, was to keep the CEO of this company from competing with the CEO of that company. But ironically, I feel like those are the people who are least affected by this law. My own experience in the tech industry has shown that non-competes overwhelmingly affect rank and file employees who frankly are not senior managers, should not be blocked from working in their field, and don't have the resources to fight it when they are. And when executives, who maybe you could make a case should be affected by this sort of thing, when they switch, there's usually not as much trouble because they see non-competes as just another negotiable item that they have to work through with their new company and their old company. And generally, they negotiate a compromise that lets them out of the non-compete agreement. In other words, this is just another way of businesses blocking their employees from doing things that their employees ought to be able to do, and it hurts everyone. So I'm really glad to see that the FTC is proposing this. I suppose it should have been an NLRB issue, but again, that's politics, and I'm not a politician. And one more thing I should point out. First off, it hasn't gone into effect. The US Chamber of Commerce is blocking it, predictably. And also, there is a carve out here in that non competes for senior executives making more than about $150,000 with strategic decision making roles, that their existing non competes are enforceable. But companies can't make new non competes with new executives, and that those will expire after a few years. So I guess they are carving out a little bit here, but overall, this is a pretty comprehensive move. It's a pretty comprehensive block, and it's one that, frankly, academics, the government, and myself would support. How about you, Tom?
So I have to be the devil's advocate here because a lot of people are thinking, oh, well, this is just going to create all kinds of problems because now I can go to work for Amazon and then learn all their secrets and then go over to Microsoft and implement all of Amazon's secrets at Microsoft. No, you cannot because a non compete is not a non disclosure agreement. Those are two separate things. Everyone knows that an NDA means that I can't talk about something, right? You sign that non disclosure agreement, and unless you're willing to violate those terms and be sued in court, you can't do that. What the problem is that people have been wielding non compete clauses as overly broad NDAs to prevent people from going to work for competitors. And we see it all the time outside of the tech industry, right? If you work in a space where, let's just say, you work for a reseller, you can't go work for another reseller for a certain period of time. Why? Well, the problem is that people think that customers are loyal to people, not companies. And so when you move from company A to company B, your customers will follow you. Well, there's ways around that. This covers those problems. What it doesn't cover is the NDA of I went and I developed a whole bunch of research and created new products for this company, and now I'm going to go over and I'm going to replicate the same work at a different company, only I'm not going to have to do all the hard stuff first. I can just give them the end result. That is what an NDA is supposed to protect. That is what a patent is supposed to protect, right? But I have a question for you, Stephen. How many of these things do you see that are actually patented?
Well, that's the crazy thing is that, in my opinion, in my experience in this industry for quite a while, again, in my experience in this industry, I see non-compete used to restrict workers' movements, to stifle innovation, to stifle competition, and as a way for companies basically to butt heads instead of as a way to actually serve legitimate business needs. As you say, trade secret misappropriation and non disclosure and that sort of thing, those laws ought to exist. They do exist and they ought to be enforced. You shouldn't be able to take your employer's secret stuff and go to a new company and do the same thing. And that, of course not. And you obviously shouldn't be able to infringe upon patents. But what I see is that time and time and time again, non-compete clauses are used basically to punish the little guy. You shouldn't quit because if you quit, you can never work in computer networking. You can't work for another computer networking firm. Good luck, buddy. Oh, you can't quit because we compete with all the cloud companies. You better not go to one of those companies. I mean, it hurts people. And as I said, I don't see this affecting a lot of executives except as an additional charge. I mean, one of the most famous non compete cases was when Mark Papermaster left IBM and went to work for Apple. This was a huge, huge deal back in 2008. But it's important to remember that the case was non compete, yes, but it was also trade secret misappropriation. So it wasn't that non compete was the problem. It was that they were just adding this on as just another count. And frankly, that's what I see as the impact of this on executives. On the little guy, well, the little guy is not going to fight it, and he's just going to grin and bear it and stick with a job that he shouldn't stick with.
The hope from the FTC, assuming this ruling actually gets to be put into law, is that we're going to see far fewer cases where employees are forced to stay at a job because their likelihood of being employed in that same industry is going to go away in the event that they leave. It should also lead to higher wages because now companies will be more willing to give you a raise when they know they can't hamstring you from moving on. I do think that what it should also end up leading to is that a lot of these trade secrets will now become patented things, and it will reduce abuse of the patent system. Because now that you have to worry about whether or not an employee can leave and potentially disclose things, even if they are bound by an NDA, you want to get that protected under law. And if you know, if you, I could wax intellectual about abuse of the patent system and trademarks and trade secrets and things like that. All you have to know is that the formula for Coca-Cola has never been disclosed because they don't want anybody to know what it is, because they don't want anybody to get close to using it. But now, we'll see if that changes the calculus of how companies want to address the situation with their employees. I think in the long term, this is going to be a very good thing, but I think it's going to mean a lot more NDAs for people, a lot more very stringent NDAs about very specific pieces, and could potentially lengthen the time that those NDAs are enforced. But, that's a legal consideration, and I'm not a lawyer the last time I checked, so we'll have to see kind of how that falls out.